As a family lawyer who does a lot of litigation, I like to win. And I am quite successful in court. But there are times when everything is going well in a party's case, and then that party does something in the courtroom that torpedoes an almost certain win. Other times, that same behavior dooms someone's case right from the start. These family court litigants are not necessarily doing anything illegal, and they might otherwise be nice people, but still, they raise the ire of a judge, and then things went badly. So to keep people from unnecessarily destroying their prospects in family court, this episode of the Ontario Family Law Podcast covers some things people should never do in family court. I'm Judge Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law, which is available in the iBookstore, Amazon, and in fine bookstores. My book goes over the family court process in detail and is an invaluable guide to get you where you need to go after separation. Few events are more important to people's lives than family court appearances. How a judge decides can set the direction for the rest of the lives of the people in the courtroom and their children. So everyone who is in family court needs to avoid doing things that can lead to bad outcomes, despite the legal strength of their case or the skill of their lawyer. Number 1, making faces in court. People separate from their spouses for a reason, and then they end up in family court rather than resolving their matters another way for a reason. That is often because they have strong feelings about each other. Often those strong feelings relate to improper actions, untruthful comments, or bad judgment of the other party. It can be hard to listen to what the ex says without reacting, so often parties roll their eyes or make faces or perform other gestures in the courtroom or on the court videoconference. Doing so is a big mistake. Except in long trials, which people want to avoid because of the incredible cost, judges do not get to spend much time with the parties in the case. Judges will not preside over cases that involve people they know personally. Even in trial, the judge only gets to see someone speak to the court in the witness box, which is a very unnatural environment. But most of the time, judges only get to read what people have to say. And if the parties have good lawyers, those words can be heavily filtered to hide the parties' less desirable traits. So for every case, judges draw a lot of conclusions about who the people are in the courtroom by how they behave, sometimes especially when they do not think the judge is paying attention. Remember that in most courtrooms, the judge sits up high, facing the parties, and the position on the dais gives them a good view of what is going on. So they can see how the parties look, and what they do, and how they react to what the other side says. People need to be very conscious of their body language at all times to give the right impression. That is even more important in videoconference court, where usually people are closer to their camera than they would be to a judge in the courtroom. Judges may base their entire decision about the character of a party and even their credibility based on what the judge sees in the courtroom, especially when the other side is talking, and especially when the other side is saying something that a party does not like. If a party looks angry in the courtroom, it is easy for a judge to believe that person has a temper, and maybe even that the person's the type of person who could commit family violence or do vindictive things. Eye rolls can suggest that the person is disrespectful or dismissive of the concerns of others. Someone who shakes or jumps up and down or grabs at their lawyer or can't keep quiet looks out of control and may be a person who will not obey court orders, at least not without strong enforcement measures. People who yell out can look just mentally ill. People who cower and cry may look helpless or unable to look after themselves. Carefully consider what message your body language and your appearance sends to the judge. 2. Dressing inappropriately. Once I was in child protection court where the judge was deciding whether a mother's kids should stay in foster care. The mom showed up to court in a bikini. She thought that the judge would appreciate the show of skin and find her way. The judge was not impressed. The kids stayed in care. There were other factors that influenced that decision, but the mother's judgment and how she looked in court was likely a big factor. That's an extreme case, but there are others where a person's attire had an impact but not what the person wanted. In another one of my cases, the wife showed up to court claiming she was destitute and relying on government benefits and desperately in need of support. But on her arm was a brand new Louis Vuitton carpet bag worth several $1,000s. She wanted to show her style to everyone on the way to the courtroom and did not think the judge would notice. The judge did. It hurt her credibility and her claims that she was desperate for money, and maybe even her judgment with respect to how she uses her money. Courtrooms are theater. Dress the part of the person you want the judge to see, but be careful not to make it apparent that you are being deceitful. If you are a successful business person, then dress professionally. Showing up in sweatpants trying to look poor will go over badly if the evidence the judge can see shows you are not. But don't wear lots of flashy new styles if you are saying that money is tight after separation. Your lawyer can give you advice about what to wear. But no matter what, make sure you dress respectfully. If how you dress says that you have no respect for the judge is not likely to respect you either. 3. Relying on the lighting in your home for court video conferences. I said a lot about how important your appearance is when you are in court and controlling what message you are sending to the judge. Once I was in child protection court with some parents who were accused of child abuse. They did not abuse their children. They had some excellent evidence on their side. But when they showed up for court by video conference, they sat in the dark room with the light coming up from below. They looked like ghouls. Their appearance was terrifying. It was easy for a judge to see that these people who looked like monsters could be the type of monsters that abuse their kids. That was an easily avoidable situation. I actually told them they had to make sure that they had good lighting when they appeared by video conference. Court is important. The appearances, including video conference appearances, can have a big impact on the rest of the lives of the parties. With so much at stake, it is worth going to a good camera store and getting some professional advice on lighting to make yourself look good. Even just a good ring light can make a big difference, but carefully planned lighting can make you look angelic. Other lighting effects can give other impressions, like how you dress. Lighting for video conference court appearances matter a lot. 4. Telling the judge when the judge has made a mistake. No matter how much you do not like what the judge is saying, no matter how much you think the judge missed an important fact or consideration, do not tell the judge off or suggest that the judge is wrong. Judges have been given the legal authority to make the decision. Their decision is, by law, correct, unless an appeal court decides otherwise. Judges, like most people, do not like being told that they are wrong. But unlike most people, they have legal powers to punish people who they think are acting inappropriately. There may be ways to suggest to a judge that he or she look at things again or consider something that the judge may have overlooked. But that is a real skill. Only the best lawyers can pull that off. And often the best lawyers can pull that off because that lawyer has the respect and trust of the judge. A party whom the judge does not know does not have the rapport with the judge or the credibility to get away with it. Then the person yelling at the judge just looks out of control or abusive or mentally ill or need to be put in his or her place. Nobody wants the judge to think that of them. A person can completely lose the sympathy of a judge, and even if there is no evidence of misbehavior before the court, the judge can see that party cannot behave and has poor judgment. The judge can base the decision on the evidence of the person's behavior in the courtroom rather than the evidence that the person planned to put before the court. If you do not like the decision, talk to a lawyer. Find out what your options are. Take the appropriate legal steps to right the mistake. But confronting a judge never works out well. If you'd like to meet with me, either to represent you or to give you some tips for your family court case, you can email me at john@schumanlaw.ca or call me at 647-342-6775. There are a lot more legal tips and good strategies for family court, family arbitration, even mediation, negotiation in the more than 100 episodes of this podcast. So please subscribe. Hit the like button so other people in similar situations can get the same advice, and ring the notification bell so that you know as soon as new episodes come out. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca and on my social media feeds. Check out my Facebook page, follow me on Twitter and Mastodon at @SchumanFamLaw, and find me on LinkedIn, Blue Skies, and Threads. 5. Holding back disclosure. Judges are very suspicious of people that they think are hiding things, and the disclosure is critical in all family law matters. Cases cannot move forward without it, so people who do not provide disclosure look dishonest and obstructive. It's a bad look. Every Ontario family court case starts with an automatic order requiring both parties to provide financial disclosure. Judges expect that both parties will have complied with that disclosure before the first court date with the judge. Check out episode 94 for more about what happens at the first court appearance. But one thing any party who has not complied with that automatic order can expect is that their family court case will get off to a very rough start. Already the judge will be upset, and that party may get a bad reputation that will haunt them in all future court appearances. If that initial financial disclosure does not completely show a party's financial circumstances, which it rarely does, expect that the judge will order more disclosure. In most cases, it is easier to just provide the disclosure than to fight over it. A spouse who willingly hands over disclosure that supports his or her position gives the impression that the evidence in the disclosure supports what he or she says. That gives credibility. Also, if a spouse really has fallen on hard times, that he or she will want to provide all the evidence to show that. Holding back makes it look like what he or she said may not be entirely correct. There are lots of cases where parties have been badly punished, even lost the most important parts of their case just because they have not provided the financial disclosure that a judge thought was important. Sometimes parties do use disclosure requests to abuse the other party, run up their costs, or wear them out searching for irrelevant documents. There are times when requests for disclosure are unreasonable. But unless a party has the advice of a lawyer or has thoroughly read my book, an ordinary person will not know when to challenge disclosure requests or how to do it in a way that does not upset the judge. If you'd like more advice on that or any other family law or educational law topic, you can email me at john@schumanlaw.ca or call me at 647-342-6775. In family court, it is very important to make a good impression to the judge. Family court judges make decisions that determine what direction the lives of the parties and their children take. Get the judge on your side by acting and dressing respectfully, being mindful of the impression you are making, ensuring you look good when attending court by videoconference, and taking the appropriate legal steps when things do not go as planned. It is also important to provide financial disclosure. There are other things you need to think about and strategies that will be specific to your particular case. To work this out, speak to a good lawyer to get advice that is specific to your situation. Again, you can email me at john@schumanlaw.ca or call me at 647-342-6775. To get a lot more information on how to succeed in family court and a detailed description of the family court process, or important information on parenting matters after separation, and information about child support, spouse support, and other financial matters related to separation and divorce, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access immediately on the iBook store and on Amazon for the Kindle version. Amazon can deliver the paperback version directly to your doorstep. Check me out on social media, and please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They're also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.